Thank you very much for that. Indeed, I hope you don't think that I've been here too much in the sense of chairing yesterday and asking some questions and now giving my presentation. But this is my core activity, reading, commenting, analyzing case law of the European courts, and I'm purposely saying the European courts, so I'm going to confront you a little bit with what type of update has been since last year, but also in the previous years, what you need to follow. Maybe as a word of introduction, the case law of the court is ever expanding. You can see that as something very good if you're interested in research in the field, because 20 years ago there was hardly ever anything of relevance that came out of the Court of Justice of the European Union for us in the media law sector. But now it's the opposite. You can hardly go to a conference such as the annual European Media Law Conference without missing a decision. And as you will see in my presentation, actually, day before yesterday, another case was handed down that I had to read yesterday evening in order to be able to present it to you. So it has a good side and a bad side. The other element that I would like to point out is I could spend not only half an hour, I could spend a whole day talking about the recent case law of the Court of Human Rights in Strasbourg, so the non-EU court on Article 10, freedom of expression. That's what it boils down to. That's where media law comes from. And indeed, every week you have cases on Article 10 in Strasbourg, and every, let's say, fourth week, it's a very important case. However, I'm only going to do that at the side because EU law is the focus of our conference, and so I will show where it is relevant in the context of EU law. So I will give one example that was already mentioned, but I will put it into context. If you apply a very narrow interpretation of what media law is, well, then you can limit a little bit more the case law which is of relevance. So if you, for example, say anything that relates to printed media, there's hardly anything because there's not much EU law on printed media. Anything that relates to audiovisual media, there is a little bit more, but not too much. Then you only have a few cases. So that's going to be the middle section of my presentation. But if you see media a little bit broader in a context how we have tried to present it to you between yesterday and today, well, then there's a much richer case law. Then you have to look at all kinds of things, such as IP law related issues. We will talk about that, communication to the public, which is of high relevance for the media. You cannot ignore that. You have to look at consumer protection law related cases. Christina just mentioned that briefly. That is sometimes very outside of the focus of media lawyers, but is of high relevance. I don't have to explain to you anymore after this morning why data protection law is very relevant, why we have to look at that, and why cases even concerning such fundamental questions as the competency of the European Union can also play out in the media sector. All of that I'm going to try and show you in the presentation today. And because I'm the last presenting person, I have to start with something that is an eye-opener. So the first case is going to be GS Media. And as those of you who know the journal, and I assume that's most of you, you can guess there's going to be something that in a moment you have to either close your eyes if you don't want to see it or look into to understand the background. This is the first case I'm going to talk about. It's GS Media. It's a case which has not yet been decided. It's a pending case, but the Advocate General has given his opinion recently. It's a case between GS Media, which is an operator of a website, against Sanoma Media Netherlands, which is the publisher of Playboy, and a celebrity, or maybe not celebrity, but a person called Britt Decker, and the photos made of her. Basically what happened is that website, GS Media, published a hyperlink, or made available a hyperlink on its website, which linked to another website, which actually was an Australian website, where you could find a zip file. And by the way, the people that click on a zip file on an alien website, that is not very recommendable, so don't do it. But anyway, it was a zip file which contained 11 photos of the photo shoot for the forthcoming Playboy edition with Britt Decker in, before Playboy was published. And the way they had received these photos was obviously illegal, so it was not with the authorization of the photographer or Playboy or Sanoma Media. And GS Media basically made a little report and said, do you want to see the photos? Click here. You clicked, you got to this other website. On the other website, there was like a preview of these photos. Well, the photos that we're talking about concerned Decker. If you want to close your eyes for a moment, it's not that dangerous. As you can see, it's a relatively harmless picture. The reason why I'm showing it to you is because we do freedom of expression here, and that means we don't have to hide away on it. And, more importantly, by now the Playboy has been published, so the actual question of the case, whether this title page and the slightly more explicit pictures from inside the Playboy could be published in advance, had a completely different economic impact, negative economic impact, than citing it now in a research presentation. What did the Advocate General have to talk about, and what will the court have to talk about? It's a request for a preliminary ruling from the Hoge Raad, so the Supreme Court of the Netherlands, and it's 4 weeks ago, or a little bit more, that the Advocate General spoke about the questions, and this is the main issue that he had to deal with. Is it, and it's an IP rights background, as I said, so intellectual property rights are in question. In the so-called InfoSoc directive, which we heard about a lot yesterday in the trans-frontier access to content, there is a provision which basically says authors have the exclusive right to decide about a communication to the public. And the question is, does it constitute a communication to the public? So in this case, a communication to the not yet printed photos. Within the meaning of the InfoSoc directive, if a link on one website refers to the content that is published on another website without the consent of the original rights holder. And basically the background to the questions is whether or not it plays a role that the content was, although illegal, freely accessible. Okay? It was there on that website in Australia for free, even though nobody had given the authorization to publish it. Is that important in deciding the question whether it's a communication to the public? So if there is a leaked information somewhere, can I republish it basically by putting a hyperlink on my website? And the second issue is, it was a relatively hidden website, this Australian website. It's called the File Factory, whatever website. And GS Media's website is relatively popular in the Netherlands. And so the other question was, if the original website is more difficult to find and the hyperlink makes it easier to access that content, so basically the hyperlink is relevant for the public to find that information, at least to make it more easily available, is that decisive for whether or not it's a communication to the public? And the case is so interesting, and please look forward to the final decision, because it is in the context of the whole linking issue. We talked a little bit about that yesterday. I don't have to repeat it all, but I would want to say there is a number of very important cases. It started with the Karen Murphy case a few years ago, but more recently Svensson and Best Water have been cases that dealt with the question of whether or not links alone, hyperlinks on the web, can constitute a so-called communication to a public. More precisely, the court came up with this idea of saying, if it's a communication to the public in the sense of the directive, it has to be the communication to a new public, so a public which did not have access to the information before. And in both these cases, which were decided last year, the court basically said, no, it's not a communication to the public if you just link, or even if you frame content from other websites on your own website. And why? Because you have to remember the way the internet functions is, it links one website to the next. And the idea was that if linking alone could already constitute a communication to the public, that might hamper the use of the way we surf on the web today. It did say it's a so-called act of communication, but not a communication to a new public. So there's two elements in there, one is given, one not. I don't want to go into the details of the cases because they have slightly diverging points, but in Best Water it wasn't even a case that was decided, it was one of these very short orders of the court where they basically said, we've already dealt with the question. Half a year later, it seems now, well, they haven't dealt with the question obviously extensively. That's why Advocate General Vartelet has developed a whole new approach, and he basically rejects any form of hyperlinking to content which is already accessible to be an act of, even an act of communication, let alone to a new public, because he says only, and here it gets important, there's the quote, only when there is an intervention of the hyperlinker which is vital or indispensable to have access to the content, then only you can see it as a communication act. What would that mean? If there would have been a paywall before the Australian website, and you couldn't have accessed the Australian website directly if you didn't pay, and you would find a link which kind of side-passed the paywall, then the intervention of me showing you the side entry, that would be, in the sense of Advocate General, an intervention which is essential, indispensable. And then it could be an act of communication. If not, not, like in this case. But remember, it's only an opinion of the Advocate General, so we see what the court makes out of it. He didn't even go into an intensive discussion of new public because he said it's not relevant, because I don't even see it as an act of communication. But he says, only in cases where the original communication is legal, because it has been authorized by the rights holder, only then can we discuss whether this previously developed idea of new public actually applies in that specific case. And I will show you in a moment that there is an even newer case that talks about this. But basically, we have to look out for this decision because it might change a little bit the holding of Svensson and Best Water, and it's an ongoing problem how to deal with online linking. And why is it relevant for the media? We heard that yesterday. Also making access, for example, to catch-up TV, or intervening with a signal which is brought from a satellite to a retransmission and putting that online, for example, in a streaming service. All of that can also be communication potentially to a new public. This is the last-minute edition, so obviously you won't find it in the slides, but you will get the updated slides after the conference. On the 31st of May, we had a decision in Reha training, and that decision is even more noteworthy, apart from the fact that it just happened, because it's a grand chamber judgment. So a year ago, the court didn't see it even necessary to do a proper judgment. It just said it's an order in Best Water. Everything has been said about communication to the new public. We just do a brief order. There was no opinion of an Advocate General, and that usually indicates everything has been said. Now, in Reha training, they decided to hand down the judgment as a grand chamber. Why do they do that? Because they think it is necessary to clarify the position of the court on this specific issue. In a training center in Germany, as you can guess, Rehabilitationstraining, television sets were installed, both in waiting rooms, but more importantly, if these patients had to do some running, for example, they had a television screen, and on that they could see the programs which were broadcast. And the court considers the following. In its decision of Tuesday, it says, putting a TV set in front of the training machinery or in the waiting room is definitely an act of communications. Patients that go in and out of this Reha center are not an insignificant size of public, because you never know how many patients there will be, and therefore it is a new public, because there's people we cannot identify directly. And the operator of this training center did actually do a targeted intervention, which reminds you of the Advocate General's words. Why? Because without the TV screen on the wall, there wouldn't have been the TV program in the room. Now, between you and me, you take out, my phone is there, you take out your phone or you take out another device, and if it's, for example, digital terrestrial television, there is easily a reception also within the rehabilitation center. You can do that, okay? You as a user, if it's freely available television. But if the provider of this training center puts it on the wall, here comes the decisive point, he's doing it because he wants to make additional profit. He wants to get more patients to come to his rehabilitation center because they can watch television while running, versus going to another rehabilitation center which doesn't have a television set on the screen. And that's why it's exploiting the original intellectual property protected content, and therefore it is a communication to the new public. So now it's going to be even more interesting to see what are they going to do in GS Media. How are they going to balance in this sense after the Reha training case. The case itself is a little bit disappointing, Reha training, because it's very short. So there's not much arguments in there. It's just the Grand Chamber says this is where we stand. And in a few months we will hear where they stand in GS Media. Let me close on that. For the IP law related, I could have done dozens of cases in that field, but it's not an IP law conference. ERA does enough activity also in IP law, so if you're interested in that, there is separate activities. I want to go now into the real media law cases, as I want to call them, and this case has been mentioned several times, the so-called new media online case. It concerns the current, not the proposed new directive, the current Audiovisual Media Services Directive, and more importantly, it concerns the scope of this directive. It basically is the question of what is covered under the current directive. Now, after all you heard yesterday, after what you heard this morning about video sharing platforms, you might say, why is Professor Cole boring us with talking about what is covered under the current directive if that is anyway going to be changed in the material scope? Well, simple point. A, we don't know what the outcome of the legislative process is going to be. B, it will take several years until the directive will be transposed into national law. So for all that time, we continue to operate with the current directive. And C, any case that happens in the member states between now and the transposition of the new directive, even if it goes to the Court of Justice a year or 2 or 5 years later, still will be decided on the basis of the law of now. So it's going to be relevant for many more years, and that's why we have to look at it. The case deals with whether or not, and therefore it's in the heart of our conference here, media convergence changes the way the scope of AVMSD has to be interpreted, especially whether it can be decisive what type of company is the provider. In other words, does it make a difference whether a newspaper publisher offers an on-demand service or a broadcasting provider? And I want to quote, because it got famous, the first line of the opinion of the Advocate General, just because it's fun. First line, okay? We all know what a horse is. That is, in his definition, an old Polish saying. You know what a horse is when you look at a horse. But in a Polish encyclopedia, there is a quote which says, we explain to you the meaning of everything, such as you know what a horse is when you see a horse. And that actually reminds me of the US Supreme Court that in a very famous decision about 40 years ago said, one judge, I know it when I see it. What was he talking about? Pornography. They couldn't find criteria to define obscenity, and they basically said, well, but it's simple. When we see it, then we know that it's pornography, which is great legal certainty for companies, okay? But we're not talking about the US Supreme Court today. Do you really know what a horse is when you see a horse? He then questions that and says, well, we all know when it is an audiovisual media service, but to define it in legal letters is very difficult. That's basically the reason why he used this quote. And why? Because there was a company, News Media Online, an Austrian company, which runs an online newspaper. It even was called daily newspaper, the Tiroler Tageszeitung online. And the question was whether the fact that it wasn't just text. Who does a website today with only text? Hardly anyone. Even universities have moving images now. So it wasn't only text, but there was a section of the website where the articles were illustrated with short videos. And so if you read the article, you pressed on a link, then you got an additional video. And the big question came up is, well, it's originally a newspaper, and in one of the recitals of the directive it says something like electronic editions of newspapers are excluded from the scope in the recitals. Could that mean that it is not covered just because it comes from a newspaper publisher or not? The question got very interesting because if you clicked on there, basically you were redirected in a specific part of the website where all the videos were listed like in a catalog. So it wasn't the video was embedded directly under the article, but you came into a subsection, and there were very many, actually hundreds of videos on demand, and that's why the Austrian regulator qualified this as an on-demand audiovisual media service, and thereby covered by the Austrian transposition of the directive. Questions put to the court were, can such a service that is discussed here, if it is sufficiently comparable in form and content to television broadcasting, be regarded as in the scope of the directive, and can or how do we have to define the principal purpose criteria of the directive, meaning that if there is a few videos, is really the principal purpose of the website to offer audio-visual content, if the vast majority is text? Or what does this principle mean, especially if the videos are very short, and does it make a difference whether they're on the main section of the website or on the additional part, whether they're supplement to the text or whether there's like a video store? And the court last October, without referring to the "we know a horse when it's a horse" quote of the Advocate General, very objectively tried to come up with some criteria and said, well, the program as it is defined in the directive includes also videos of short duration. Remember that that's one of the changes to the material scope that is proposed by the Commission. Why? Because they have to follow this judgment. The quote that they use is, if these short videos consist of local news bulletins, sports and entertainment clips. That's regrettably in the final holding. If you leave away that and say, well, if it's short duration video clips in other fields than that, would it still apply, the ruling, or not? Questionable, but probably yes. And if it is put on a subdomain of a newspaper website, then it is definitely a program. Question is it a principal purpose of the website to offer these audiovisual content clips? Well, you have to interpret it in the following way. It has to be separate from the main service, both in content and form. So if you can see it as independent from the other journalistic activity, then it is an AVMS. If it's just an add-on, or as was yesterday already mentioned, this very nice word of indissociable complement to the main website, then it's not independent, and then it's not to be seen as an audiovisual media service on demand. So basically, it depends on you as a provider how closely you put the links between the content, text, and the content, video. The more separate it is, the more likely it is that you are qualified as an AVMS on demand. And actually, that's the reason why, for example, The Sun in the UK changed from offering Sun TV to putting all of their videos on the normal Sun newspaper section and linking it much closer to the main text, because there was a similar case which didn't go to the European Court, but in the UK. So that was the first of the AVMSD cases. To be honest, it'll be much more interesting to see what the new provision will bring forward once it's been decided on, but as I told you, you will have to wait at least 5 years, if not longer, until the very first case concerning the new directive will reach the Court of Justice. The second case is maybe even more anachronistic, if you want, in the sense of it talks about something very specific in broadcasting advertising, but also that the court had to decide on it, and did so against the background of two provisions of the directive. Both of them have to do with commercial communications, or better known as advertisement. Even though in the reform, we heard yesterday, many things will change about that. We will most likely have no more a 20% rule, meaning that it limits to 20% of an hour advertising, but we will have a daily limitation. This case concerns exactly that old rule, and more specifically, how to calculate the 20%. So how do I calculate what is advertising content in order to come up to this maximum allowed time for advertising? In the case at hand, a Finnish broadcaster inserted, and that's absolutely more or less normal behavior in the industry, blank spaces, very short black spaces, differing length between milliseconds and seconds, so-called black seconds, between advertising clips. So that kind of separates them a little bit more from each other. You don't see that normally, but it counts up in terms of a couple of seconds. And in addition, it also used split screen technique. That's also not really state of the art in the sense of something very new. It's been around for many years, where on one side the end titles of a program roll, while on the other side there's already the next program being announced, and on that announcement there was already the sponsor logo of the next program, which was sponsored. But the next program had not yet started. And the regulator in Finland said both of that is advertising. It's to be counted within the advertising time, and actually you overstretched the 20%, and that's why we have to fine you on that, or we have to order you not to do it anymore. The courts were not sure how to deal with it, so they asked the Court of Justice the following questions. One concerns Article 19, you have it in your papers if you want to look it up, and the other 23. One is, can identifications of a sponsor be regarded as advertising if they are not shown in direct connection with the sponsored program? Because if they are shown in direct connection with the sponsored program, the directive says, then you don't count them. But if you basically say the following program is sponsored by this company, and then you have another program in between or advertising, then it's not within this exception of the AVMSD, and the question was whether or not it then has to be counted as real advertising. And we're talking probably about half a second, 1 second, or 2 seconds of time. And the second is Article 23. That concerns whether or not the split screen means that you have to also count the second half of the screen as being a part of the advertising, and more importantly, what type of separation signal you need between the program and the advertising if it's on a split screen. Lastly, whether the black seconds have to be counted or not. And this is the result of the court in February. It's a very fresh decision as well, which unsurprisingly was quite heavily criticized by some, because they say this is so micromanagement. We're talking about media pluralism, independence, media freedom, and here comes a decision which says the following, that basically the Finnish approach was correct, to be relatively strict. The separation requirement means the two different parts have to be, advertising has to be recognizable and they have to be distinguishable. So there is an idea that the Audiovisual Media Services Directive protects viewers from excessive advertising, and that's why they have to know when it's advertising, and in addition, they also have to be protected from too much advertising. And the way it can be reached is, in split screen, it can be acoustic. You will now see advertising, or it could be optical, a banner saying the following is advertising, or it could be spatial distinction, and spatial distinction could be split screen. So in principle, that is allowed, but the following 2 points are more important. If you put sponsorship announcement in this split screen, well, then that is already a reference to a future sponsored program. It cannot be seen as a sponsorship announcement, and it needs to be counted only within the program, directly before and directly after a sponsorship announcement is not counted as advertising. And the black seconds, no discussion. When they happen within the advertising time, they have to be counted within the advertising time. The Austrian regulator has given guidance to broadcasters since this decision, and it says, don't forget to count not only in between, but also the very first black second and the very last black second when you calculate your advertising time. This may seem theoretical to you, because 12 minutes, a couple of seconds, does that really make a big difference? But it can make a difference in the calculation of what type of ad spot you can still put on. In 5 years from now, we might not even have traditional television advertising spots, but we're still discussing such issues. Let's leave the very detailed, specific questions of the AVMS directive, and this case here, please don't read it because it's so specific, I wouldn't want you to go into it in detail, but I'm showing it to you for the following reason. It concerns a convention which is being elaborated at the Council of Europe, so again, outside of the European Union. And it's absolutely not in the focus of our topic, but I would like to mention it on a side note, because it might be important to see whether at all there is a future for the so-called Convention on Transfrontier Television of the Council of Europe. There is a parallel international treaty at the Council of Europe to the former Television Without Frontiers Directive. And for the same reason, as we will see in this case, it has not been modernized, because the European Union, in the form of the Commission and the Parliament, is of the opinion that in that field, both in IP law as well as in the field of negotiating a treaty on television, there is an exclusive competence for the European Union. If there's an exclusive competence of the European Union, it means that the Council cannot take a decision. In this case, the Council had taken a decision how to approach the negotiations. Only the negotiations about the Convention. The Commission and the Parliament took the Council to court, and the Council lost. It's a slightly older case, it's of 2012, but it's important to remember that the court sided with the idea that in the area of IP and media, we have a strong competence in favor of the European Union, which might mean that we will never see a reform of this Convention on Transfrontier Television. That's quite likely, or it will have a completely different scope than the AVMSD. I will skip this case in view of time. You will find it on the slides. I just would like to point out why I put it on the slides. It's again a very old case, 2013, but it raises questions of consumer protection, not from a media perspective, audiovisual, but concerning a newspaper. And it shows that it's not enough to look into your directives and into your regulations which apply to your scope, but you also have to look at horizontal directives, such as the Unfair Commercial Practices Directive, which might prohibit a specific type of advertising. As I say, no details on there. I would just like to point out that in the reform to the AVMSD, we have the same issue. We heard it yesterday. The accessibility requirements for people with disability is going to be deleted, and instead the horizontally applicable directive on accessibility requirements, there's only a proposal out until now, but I'm sure it will come, will be applicable. So you cannot refrain from looking outside of what is actually directed to you as a media company. The other case I would like to mention is, again, only an opinion, so we don't have to go yet into very much detail. The opinion was handed down in March, and it concerns the liability framework of the e-commerce directive. So, in the e-commerce directive of 2000, there is the idea that only if you're a content provider, you are fully responsible. We heard it a little bit in Christina's presentation. If you merely give access to content, you're not liable, making it very simple, until the moment that you know that you're making available some illegal content, and then you have to take down that content. But as long as you're doing all of that, you're not liable for illegal content, basically. And the context here is that the question was whether or not these rules play a role in the provision of freely accessible Wi-Fi networks. All of you are using the MCE bus, probably. That same network, if you take your computer and walk outside of the building, is probably accessible. So somebody might be sitting at the road outside now using that network without a password and downloading from illegal sources films. And Sony Music Entertainment, which was the other party in this case in Germany, might not be happy about that, might not know who the person is down there, but might want to approach MCE saying, well, MCE can pay me for the violation of my copyright. And that's basically what happened in the McFadden case. And the Advocate General said this German system of making such providers of information society services liable, that's not going to work. He is proposing to the court to decide as follows. Yes, every person who offers as a side activity an open Wi-Fi, for example, if you go to a cafe, you don't go to the cafe because of the Wi-Fi, you go to drink a coffee, at least hopefully. And if as a side activity you can also use the Wi-Fi, then it still means the person is offering a so-called information society service, but you cannot directly go against that provider. You have to find the original rights violator, the one that used the Wi-Fi, because what the provider here does is only a mere conduit, and therefore has to be under the so-called privileged framework of the e-commerce directive. What you can do is, you can maybe do an injunction against this provider. It means you cannot ask them for paying damages, but you can say, from now onwards, I want you not to allow your users to give access to this and that website, because it is illegal content, but he's made restrictions, and those are in the brackets. These injunctions may not lead to the following three situations: that A, it's impossible to offer this internet connection, so if the effect would be that the service has to be shut down. Secondly, if the requirement is that every single access has to be password protected. So this company here, MCE, is in good company, because it means they are not asking for a password, and the Advocate General says it should not be a requirement. And thirdly, you cannot ask the provider to monitor traffic. So if one of you illegally is downloading maybe even hate speech content currently under that network. If Spoonar's proposal goes through, in future it's not possible to hold MCE liable for it, except to possibly make an injunction. So that means we have to also look out in that direction. Already nearly coming to a close, although I still have 2 cases. I'm now leaving for a moment Luxembourg, meaning the Court of Justice, and going to Strasbourg, and talking about the case of MTE and Index Hungary versus Hungary. The background is Article 10, and the question of whether or not you can oblige providers of fora, online fora, where you can leave comments, user-generated comments, whether you can oblige these providers to monitor what their users post on the website. I'm not actually going to talk about the Delphi case because this is the more recent case. It was decided on the 2nd of February of this year, but it's the follow-up to the Delphi case. And it's interesting because it touches 2 things. The first is, does Article 10 basically give you a right of access to the internet, or even more, a liberty of commenting on the internet? Is there different rules applicable on the internet about how you can comment and what types of posts you can make? And the second, and here it gets interesting, whether the liability framework of the European Union's directive, in the way it is applied in the member states, might impact negatively the human right out of Article 10. So although the court in Strasbourg is not to review EU law, indirectly, due to the effect of EU law, it does. And the context of the decision is, as we heard, there's earlier case law, the Delphi case of last July, Grand Chamber judgment, where it basically said an Estonian website where there were very aggressive comments posted was responsible for those posts and could be fined for 300 euros, although they didn't author these comments. There's a lot of debate about whether that was just because it was a very low fine, because the comments were really extreme. They basically said things like, you should burn the person that is concerned about this article, so they were really harsh, or whether it really was a general tendency of the court to say online platform providers should have a certain liability. In Cengiz versus Turkey, which was decided a couple of years ago, and concerned a very old ban in Turkey on YouTube. There were a couple of academic colleagues of mine that wanted to post something on YouTube, and YouTube had been banned completely for 2 years by Turkey. And many years later, the case was decided, and it said such a blanket ban is definitely not compatible with Article 10. You also have to take that in consideration, not only the Delphi case, because there they said making responsible YouTube for some videos which are potentially illegal, and therefore blocking access for all the users to YouTube, that is not a proportionate measure. And if you look at the 2 cases together, there is a certain amount of criteria that was developed. What type of comments, what's the context of the comments? Basically, has the provider invited people to make raunchy comments, harsh comments, or is it a rather moderated context? What are the effects? Like, is it very negative, the reputation of the person damaged that is concerned? And as a result, when they applied the idea of the secondary law, the liability of EU law rules, they came in this case to the result to say, no, it's not possible to fine MT and Index for user-generated comments. So in a way, they're moving a little bit away from Delphi. So only very exceptionally, it is possible to hold a platform provider under the new case law liable for user-generated content. We are still working, I think the academics are still working on distinguishing what is the difference between Delphi and MTE, although there are some criteria where you can say that's why it is different. Okay? I'm mentioning the Cengiz case because you might know that Turkey a few months ago blocked access for a few days to Twitter, and Brazil did the same thing. A court in Brazil said for 2 days no access to Twitter. So it is a relevant topic. Let me close on one final case, and that is the case of Patrick Breyer. It is pending. We have an Advocate General opinion of the 12th of May. And the background is this time the Data Protection Directive, the one we heard about this morning being replaced by the GDPR. And it basically concerns the question, to break it down, and the main question is whether IP addresses are to be regarded as personal data, meaning whether or not the fact that you alone, if you use a computer, you have an IP address which can be identified, but typically not who you are. Your service provider might be able to put that data together with something else and make you identifiable. For example, because he has your billing address. But even without that, whether merely the IP address can be regarded as personal data. And the Advocate General said yes, under the old directive. The GDPR concerning that is even stricter. And why is it relevant for the media? Well, we heard about personalized TV. Think of smart TV. If you connect on a smart TV to the internet, the first thing that happens is your IP address is registered in order to send to you the offer, only the offer that you can use your connected device by connecting to the internet. And already in that first step, you are in principle using an IP address, and if this decision goes down as it is, already that is personal data. What do we need for personal data? What did we learn this morning? We need consent. How can you ask somebody before you even know who he is to give consent? It's a very difficult outcome. In short, what does this overview show you? The overview shows you it's become more complex to move around in this sphere as a media service provider, and it is far from easy to know where the Court of Justice jumps in certain decisions. And if you then put it into the context with Strasbourg, it is not always predictable what will come next. For me, it means a lot to do. For you, hopefully, it means a lot of interest also in future to follow conferences such as this. And with that, thank you very much.